Good afternoon, everybody. Thank you so much for joining us. I know you guys just introduced, but for the sake of a recorded version of this, I'm going to kind of reintroduce you. So in honor of Elder Abuse Awareness Month, we at Loudoun Senior Interest Network are delighted to present our June education event titled Protectors of the Vulnerable. Today, we're joined by Leslie Barnes, Senior Assistant County Attorney from the Loudoun County Attorney's Office, and Emily Bremer Thomas, Adult and Aging Services Specialist from the Loudoun County Department of Family Services.
I am showing that there's an authorization on file for skilled nursing.
All right, Cecilia, I'm gonna just ask you to mute.
1152.
Kathleen, could you mute?
We requested a continuation for that until.
No, haven't gotten that yet.
Are you able to mute, Derek?
Yeah, she's been muted.
Thank you. In addition, Buda Bibaraj, Commonwealth's attorney from the Office of Commonwealth's Attorney for Loudoun County, and Shaniqua Clark Nelson, her chief deputy, are with us. Ladies, thank you all for joining us and spreading important information related to the protection of our aging population, which is key to our mission here at ELSIN. So to kick off this program, we're going to turn to Emily. Thank you again for joining us.
Thank you for having me and inviting me to speak today. I'm going to share some information about our unit, how APS works, how you can make a report, and then briefly go over some of the other services that we offer to older and disabled adults in our community. Derek, I'm not able to share my screen.
Okay, let me go ahead and enable that. Just give me just a second.
I think I already did it.
Can you try again?
There we go. Thank you. So our unit has two branches. One is Adult Protective Services, and this is the side where we investigate abuse, neglect, and exploitation. And the other side is our Adult Services, which focuses on prevention and long-term care services for adults. So for Adult Protective Services, we investigate when an adult is over 60 or 18 to 59 and incapacitated or suspected to be incapacitated. Our goals as APS are to stop the abuse, neglect, and exploitation by protecting the adult in the least restrictive manner. We always aim to help adults remain in their homes and age in place for as long as is possible for them. And if it's appropriate and they consent, we would assist with finding a nursing home or assisted living placement. So in order for an adult to be considered incapacitated, they have to meet this definition. That's part of the Code of Virginia. It's any adult who's impaired by reason of mental illness, intellectual disability, physical illness, advanced age, or other causes to the extent that they cannot make or carry out decisions for their well-being. This could be someone that mentally can't make decisions or who's physically incapacitated if they're bed-bound or wheelchair-bound and totally dependent on someone else for care. They would still meet that incapacitated definition. So in order for us to investigate when someone's under 60, this is the criteria that we're looking for. So I'm just going to go over some definitions for abuse, neglect, and exploitation. When we investigate, this is the criteria that the allegations have to meet. So for abuse, this covers physical, sexual, and mental abuse, and it's the knowing and willful conduct that causes physical injury or pain, including confinement as punishment or a substitute for treatment, except when it's part of a care or treatment plan. So this The abuse has to be willful, purposeful, and it does include unreasonable confinement, which could be anything from bed or chair restraints to chemical restraints, such as over-medicating an individual. This also includes isolating someone. We've had instances of older adults who were wanderers and were locked in their home by their family with the thought of keeping them safe. But unfortunately, they would not be safe in that instance, and we would consider that abuse because they couldn't get out in an emergency. And then the Code of Virginia doesn't have a definition for verbal abuse. Any allegation of verbal abuse has to meet this mental anguish criteria, which is indicated by a state of emotional pain or distress resulting from an activity of a perpetrator. And the intent of the activity is to threaten, intimidate, humiliate, cause sorrow to the individual, and it caused them distress. So it has to, again, be the intent to harm is there and the individual was caused distress. We've had an instance where a daughter was accused of verbally abusing her father. It turned out through our investigation, refused to wear his hearing aids, so she often had to shout at him. It was not her intent to cause him any pain or harm, and he wasn't feeling distressed. They were just trying to adapt and communicate. So in that case, it wouldn't have met that mental anguish definition. Then we have exploitation, which is the illegal, unauthorized, improper, or fraudulent use of an adult, their funds, property, benefits, or resources for another's profit or advantage. This is anything from internet phishing scams or romance scams online, and it extends to family members that are in charge of an adult's finances. They may refuse to pay for services to care for the adult, which results in neglect, and that would all fall under exploitation. And then neglect, which is the knowing and willful failure by a responsible person to provide treatment, care, goods, or services, which results in injury or endangers the adult. This includes self-neglect, so it could be either a caregiver or responsible person or the adult themselves that doesn't know how to make those decisions or get services in place to help themselves. So some of the signs of abuse, neglect, and exploitation: multiple or severe bruises, burns, welts, unexplained injuries, pressure sores. Often an older adult might complain of weakness in an arm, a limb. That could be a sign of a broken bone. Untreated medical or mental health problems, medication not taken as prescribed, dehydration or signs of malnourishment. An adult that appears to rapidly be losing weight could be a sign of neglect. Unsafe living conditions, rodents, or not having adequate utilities in the home, broken windows or exposed wires could be a sign of neglect or self-neglect. And then exploitation. Adults who are unaware of how much money is in their account, maybe they don't know how to access their accounts or who's in charge of their money. Frequent checks made out to cash, large withdrawals, missing personal belongings, or suspicious signatures. Also altered checks that look like they've been changed could be signs of exploitation. So anyone can make a report to APS, but Virginia requires mandated reporters to immediately report suspected abuse to either the local or state hotline. Mandated reporters are anyone licensed by the health board, except for veterinarians, but it also includes mental health workers, EMS personnel, guardians, conservators, law enforcement officers, and anyone that provides care to an adult for compensation. So even if they're not licensed, a home health aide is a mandated reporter. And also anyone that works in a facility or a public or private agency with adults, whether they provide direct care or not. So that includes front desk staff or housekeeping staff, anyone that's working in that facility. So the responsibility of a mandated reporter has been fulfilled once they've provided a description of the situation and the adult and the information that caused the suspicion of abuse to one of our hotlines. There's a few exceptions. There's no obligation to report if you know a report has already been made for the incident. If the investigation is ongoing, you don't have to make an additional report unless you suspect a second type of abuse is now occurring. And in hospitals, other facilities, it may be policy that the staff member reports to a supervisor who reports to APS. So your duty would be fulfilled once you report it to your supervisor. However, Virginia Code does state that the facility cannot stop you from reporting directly to APS. So to make an APS report, you can call us at our local hotline number from 8:30 to 5 on weekdays, or the state hotline after 5 and on holidays and weekends. But we always have a local APS worker on call to respond to reports after hours. You have a right to be anonymous even if you're a mandated reporter. We never reveal your identity except by court order. So you would need to provide a location, age, and description of the adult when you call. Their alleged incapacity or why you suspect that they're incapacitated, a description of the abuse, and any safety concerns for our workers. We often go out with law enforcement, so any information about unsafe conditions in the home, or if even the client might consider a social worker a threat when they arrive, is important for us to know. And once we receive the report, we'll evaluate it to see if it's valid for us to investigate. So it has to meet the following criteria. It has to be a living, identifiable adult. We don't investigate if someone has passed away. We would refer that to the medical examiner's office. And we don't have to have a name, just enough information and description to find the correct person and where they're located. We have to know that they're 60 years of age or older, or again, suspected to meet that incapacity definition. The circumstances have to meet our definitions for abuse, neglect, or exploitation. And we have to be the agency of jurisdiction, which just means that the abuse occurred in Loudoun County or was discovered here. Once we've determined a report is valid, our investigator will make an unannounced home visit to interview the client within 24 hours or up to 5 days. We go out in 24 hours for any case where the adult has imminent risk of harm. For sexual abuse and any physical abuse allegation, we'll respond immediately. Any criminal activity or sexual abuse, we refer to law enforcement as well. We often do joint investigations with them, as well as licensing and regulatory Board of Health agencies. Once we do our investigation, we'll offer appropriate services and resources for the adult, like counseling, nursing home placement, if it's appropriate, emergency food, refer them to legal services. If they have capacity, they do have a right to refuse our assistance. We can't force services on anyone. If they don't have capacity, they could be court ordered to receive the services, but we would refer to a medical professional to make that determination. So we have 45 days for our investigator to determine a disposition, and you as a reporter will receive a short letter at the conclusion with the outcome. It won't be too detailed because the details of the investigation are confidential. But if you were a named reporter, you will receive a letter letting you know that the investigation has been concluded and we offered services. So in fiscal year 2020, we received 694 reports and 440 of those were investigated. We had 216 substantiated cases and 37% of those cases, the adult accepted services. We have a success story I just wanted to share. A client, we opened their case in September of 2019. They were calling EMS multiple times a day. His memory was diminishing. He couldn't keep his apartment clean. He stopped going to the doctor and taking his medications. He didn't have any family or supports to help him. And then his dog passed away and he started having anxiety attacks. So our APS worker was able to get an emergency custody order so he could be evaluated in the hospital. And then they were able to find an assisted living placement for him with memory care services within his budget and helped get him admitted to the facility in April 2020. So to go back to the other side of our unit, adult services, we have 4 main areas of services that we offer for older adults in the community. The first is our companion services program, which provides up to 25 hours a week of personal care services like light housekeeping, help bathing, getting dressed, light meal preparation. We contract with a home health agency, the medical team for these services. And we have 131 adults that currently are in the program. And in 2020, 97% of our clients were able to stay in their homes for at least 1 additional year while in the program. We also do screenings for adults to go to assisted living facilities, nursing homes under Medicaid, or to get waiver services through Medicaid in place. That's again, personal care services so they can stay in their home as an alternative to going to a facility. And then we have intensive case management. For this program, the adults have to be 60 and older or 18 to 59 with an impairment. They don't have to be fully incapacitated, just to have a disability or impairment that's impacting their ability to do their daily tasks. So they have to call in to request and consent to services. And then our adult services worker will make a plan with them and help connect them to any services or supports they're looking for, like housing, filling out Medicaid applications, getting transportation assistance. We want to prevent any emergencies or crises and get them long-term help. And then our last service that we provide is we review the guardianship cases for Loudoun. Guardians are required to submit an annual report and we review those to make sure there's no APS concerns. And we currently have 453 guardianship cases in Loudoun. And most of those, I think about 80% are actually for individuals under 60. So that part of our guardianship cases is really growing, the individuals under 60, not over 60. So if anyone has any questions, let me know. But thank you again for having me.
Thank you so much, Emily. It doesn't look like we have any questions at this time. So we will move on to Leslie. Thank you so much.
And if any questions do come up, feel free to drop them in chat. We're happy to keep the conversation going there.
Okay. So my name is Leslie Barnes, as was stated earlier, and I am one of the attorneys that represents the Loudoun County Adult and Aging Services Department. Today, I'm going to discuss some of the cases that adult and services cases, adult and aging services can file in the circuit court here in Loudoun County. Those types of cases are protective services cases. Sorry. Oh, there we go. Protective services cases, guardianships, and conservatorships. I'm going to begin with the protective services cases. And if an adult is found to be abused, neglected, or exploited, adult and aging services can provide services. Some types of abuse, neglect, or exploitation are sexual abuse, physical injury, financial exploitation, physical neglect, or medical neglect. Those are all the things that Emily kind of just talked about, and she went into a little more specifics about them. Before going any further, I do want to refresh your memories in regards to the definitions for an adult, as well as an incapacitated person. Again, an adult is any person 60 years of age or older, or any person 18 years old, who is incapacitated and who resides in the Commonwealth. As far as the definition of an incapacitated person, it is the same as the definition that Emily just provided. Basically, it's an adult who is impaired by reason of mental illness, intellectual disability, physical illness or disability, advanced age, or other causes, to the extent that the adult lacks sufficient understanding or capacity to make, communicate, or carry out responsible decisions concerning his or her well-being. All right. Adults, or the definition of adult for the purpose of this discussion, does not carry the normal everyday meaning that we have or that we know for an adult. So if an adult is found to be abused, neglected, or exploited, adult and aging services can provide voluntary adult protective services. They are voluntary because the adult requests these services or affirmatively consents to these services. If an adult does get voluntary protective services, the local department, which is Adult and Aging Services, will pay for these services unless the adult agrees to pay for them or the local circuit court orders that the adult pay for the services after finding that the adult can pay for the services. So basically, Adult and Aging Services will pay for any voluntary services unless the adult can do so themselves. Then they'll pay for them, or they can agree to pay for them as well. All right. Next slide. The other type of services that Adult and Aging Services can provide are involuntary adult services. And they can provide those services if an adult lacks capacity to consent to receive adult protective services. Then those services can be ordered through the court, or they can be provided through an order wherein a guardian or a conservator has been appointed for an adult. If Adult and Aging Services has to go to court in order to get these involuntary services in place, then they need to seek an emergency order. And in order to get an emergency order, the first step would be filing a petition for an emergency order. Now, that petition, once it's filed, Adult and Aging Services has to give a written notice of the time, date, and place of the hearing to the adult, as well as the adult's spouse or next of kin. And they have to give that notice within at least 24 hours prior to the hearing. In regards to the hearing itself, the adult has the right to be present at the hearing and represented by counsel. If the adult is indigent or lacks capacity to waive the right to counsel, then the court has to appoint a guardian ad litem for that adult. After the hearing, the court may issue an order authorizing the provision of adult protective services on an emergency basis if the court finds that 1, the adult is incapacitated, 2, an emergency exists, 3, the adult lacks the capacity to consent to receive adult protective services, and 4, the proposed order is substantially supported by the findings of the local department that has investigated the case. If the court does find those things at the hearing, it shall enter an order, and the order shall adhere to the following limitations. First, the order shall only order such services as are necessary to improve or correct the conditions creating the emergency. Second, the order shall only order services for a period of 15 days, no more. Now, if services are still needed after those 15 days, that original order can be renewed for another 5-day period, but that's it, 1 renewal. The order shall also appoint the petitioner or another interested person as temporary guardian of the adult, if that's appropriate. But that appointment of a temporary guardian only lasts until the expiration of the order. The court can also appoint the petitioner or another interested person as temporary conservator of the adult until the expiration of the order as well, if that's warranted and appropriate. In these cases, the court shall only authorize the intervention which it finds to be least restrictive of the adult's liberty and rights while consistent with his welfare and safety. Essentially, in these cases, the court takes a least restrictive approach, meaning it only orders the bare minimum needed in order to correct the situation. You should know that an emergency order can be set aside or modified at any time if there is evidence that there's been a substantial change in circumstances. Emergency orders can be modified. They don't necessarily have to last the whole 15 or 20 days, depending on the circumstances. If an adult continues to need services after the renewal order has expired, assuming there is a renewal order, the temporary guardian or conservator or the local department, meaning adult and aging services, shall immediately petition the court to appoint a guardian and or conservator. So if whatever the emergency situation is still ongoing at the end of the expiration of the emergency order, then someone needs to petition for a guardian or conservator. And now we're going to talk about guardianship and conservatorship cases. First, let's start with the definitions of a guardian. A guardian means a person appointed by the court who is responsible for the personal affairs of an incapacitated person. That's important. The person has to be incapacitated. Including responsibility for making decisions regarding the person's support, care, health, safety, rehabilitation, education, therapeutic treatment, etc. A conservator means a person appointed by the court who is responsible for making the estate and financial affairs of an incapacitated person. So the guardian is over the person, the conservator is over the finances. That's a simple way of putting that. The other term you need to be aware of is a guardian ad litem, and that's an attorney appointed by the court to represent the interest of the respondent and whose duties include evaluation of the petition for guardianship or conservatorship and filing a report with the court. Now, let me just stop for a quick second and do another definition. One is petitioner And a petitioner is basically the person who files the petition for guardianship or conservatorship. The other term you need to know is respondent. The respondent is the adult that's the subject of the petition, the person you're claiming needs a guardian and or conservator. All right, let's go on to some more definitions. You should know that a guardian and a conservator can both be limited, meaning they're only given certain powers, authorities, and duties. They can also be just temporary, meaning their authorities, duties, and powers are limited by time. They're only going to be in place for a certain length of time. So in order to get a person a guardian or a conservator, just like with an emergency order, you have to file a petition. And basically, it's a petition for appointment of guardian or conservator. Some of the things you should know is that any person may file a petition for the appointment of a guardian or a conservator or both. The petition has to be filed in the circuit court of the county or city in which the respondent is a resident or is located. And the petition must contain information such as the following: the petitioner's name, place of residence, post office address, and relationship to the respondent. It has to have the respondent's name, date of birth, place of residence, post office address, and the sealed filing of the respondent's social security number. The petition also has to have the names and post office addresses of the respondent's spouse, adult children, parents, and adult siblings. And if you don't have that, then you need to provide at least 3 other known relatives of the respondent. The petition also has to state the type of guardianship or conservatorship that's being requested. And it also has to provide a brief description of the nature and extent of the respondent's alleged incapacity. Further, it has to provide the name and post office addresses of any proposed guardian or conservator, the person that you want the court to appoint to be the guardian or conservator, essentially, of this adult. The petition has to provide a statement of the financial resources of the respondent. It has to request a guardian ad litem for the respondent. And then finally, it has to have a statement of whether the petitioner believes that the respondent's attendance at the hearing would be detrimental to the respondent's health, care, or safety. Once you've got this petition drafted and filed, then you need to have the petition served. Now, what you have to serve on the respondent is a notice of the hearing, a copy of the petition, and a copy of the order appointing a guardian ad litem. If you do not properly serve the respondent, then the case could be dismissed, because failure to properly notify the respondent is jurisdictional. And if you don't do that, then the court does not have proper jurisdiction of this matter, and then the case could be dismissed. So it's very important that the respondent be properly served in these matters. Additionally, the petitioner shall send via first-class mail a copy of the notice and the petition at least 7 days before the hearing to all of the adult individuals and to all of the entities whose names and post office addresses appear in the petition. So you've drafted your petition, you've filed your petition, you've now served your petition. The next thing that would happen is the court needs to appoint a guardian ad litem. On the filing of every petition for guardianship or conservatorship, the court has to appoint a guardian ad litem to represent the interests of the respondent. Now, the guardian ad litem has certain duties, and some of those duties are to personally visit the respondent, the person you're seeking to get either a guardianship for or a conservatorship for. The guardian ad litem has to advise the respondent of his or her rights. The guardian ad litem has to recommend that legal counsel be appointed for the respondent if the guardian ad litem believes that counsel for the respondent is necessary. So it is conceivable in some of these cases that a respondent not only has a guardian ad litem appointed to represent them, but an individual private attorney. The guardian ad litem also has to investigate the petition and evidence. They have to request an additional evaluation if necessary. They also need to file a report with the court that lists their findings, their thoughts, and their opinions. Finally, the guardian ad litem has to personally appear at all court hearings and conferences. In these hearings, the respondent has the right to be represented by counsel of the respondent's choice. If the respondent is not represented by counsel, the court may appoint legal counsel if it determines that counsel is needed to protect the respondent's interest. The next thing in these matters is there needs to be filed an evaluation report. Now, earlier I spoke about a GAL filing an additional evaluation report. So this evaluation report is the one that's usually filed by the petitioner. But the GAL may think, well, I need to go get another one, or I want a second opinion. And so that's the additional evaluation report that I was referencing earlier. All right, so this evaluation report that has to be filed, the GAL doesn't have to file an evaluation report, but the petitioner does. And this report has to do the following thing. It has to evaluate the condition of the respondent. It needs to be filed under seal with the court and within a reasonable time period prior to the hearing on the petition. The report has to describe the nature, type, and extent of the respondent's incapacity, including the respondent's specific functional impairments. Finally, the report has to state the nature of the professional license held by the person who conducted the evaluation. Usually these evaluation reports are done by doctors or some sort of licensed mental health professional. All right, so the report is filed, and then you go on to the actual hearing on the petition. Now, a couple of things you need to know about the hearing are, one, the respondent is entitled to a jury trial if that's what the respondent wants. These are not necessarily bench hearings, which is unusual for a civil case, but in these, the respondent can have a jury if that's what they care to have. Also, you should know the proposed guardian or conservator shall attend the hearing except for good cause shown. So the person you want to be the guardian or conservator of the respondent has to be at the hearing unless they have a very good reason for not being there. Also, the respondent is entitled to be present at the hearing and all other stages of the proceedings. So if the respondent wants to be present for whatever reasons, then that needs to occur. Finally, you need to know that the evidentiary standard is clear and convincing that the respondent is incapacitated and in need of a guardian or conservator. So unless the court finds at the standard of clear and convincing, which is above preponderance of the evidence, but below reasonable doubt, the court can't appoint a guardian or conservator. All right. At the hearing, some of the factors that the court is going to consider are the following. First, the limitations of the respondent, the development of the respondent's maximum self-reliance and independence, the availability of less restrictive alternatives, the extent to which it is necessary to protect the respondent from neglect, exploitation, or abuse, the actions need to be taken by the guardian or conservator, the suitability of the proposed guardian or conservator, and the best interest of the respondent. If after considering all those factors, the court believes that a guardian or a conservator should be appointed, then they shall issue an order. And that order shall state some of the following things. First, it has to state the nature and extent of the person's incapacity. It has to define the duties and powers of the guardian or conservator so as to permit the incapacitated person to care for himself and manage property to the extent that he is able. The order shall state the legal disabilities of the respondent. The order shall state whether the appointment of a guardian or conservator is limited to a specific length of time. And the order shall set the bond of the guardian and the bond and surety of the conservator, if there are any. So if the court finds that the guardian or conservator needs to be appointed, this order needs to state these things, and then let's say it's a guardian that's appointed, then that guardian will have the following duties and powers. Guardians are to maintain sufficient contact with the incapacitated person in order to know his or her capabilities, limitations, needs, and opportunities. He's to visit the incapacitated person as often as necessary. Encourage the incapacitated person to participate in their decisions and to develop or regain the capacity to manage his or her personal affairs. The guardian is to consider the expressed desires and personal values of the incapacitated person when making decisions. The guardian is to act in the incapacitated person's best interests, to exercise reasonable care and prudence, diligence and prudence, and to seek court authorization before changing the incapacitated person's residence to another state or consenting to the termination of the person's parental rights or changing the person's marital status. If a conservator is appointed, they have some of these duties. They are to take care of and preserve the estate of the incapacitated person. Because remember, the conservator is the person of the person's finances, not the person himself. The conservator is to apply the income from the estate to the payment of the debts of the incapacitated person. The conservator can also pay themselves for being the conservator. The conservator is to encourage the incapacitated person to participate in decisions, to act on his own behalf, and to develop or gain the capacity to manage the estate in his or her financial affairs. The conservator is to ratify or reject a contract entered into by the incapacitated person, to maintain life, health, casualty, and liability insurance. And finally, the conservator is to secure loans or renew existing loans if appropriate. If a conservator or a guardian is appointed, and even if they're not, there are certain fees and costs associated with these proceedings. And the petitioner normally pays the filing fees and costs. However, if a guardian or conservator is appointed, then the court finds that the petition was brought in good faith and for the benefit of the respondent, the court can then order that the petitioner is reimbursed from the estate of the respondent for all reasonable costs and fees, but only if the estate is available and sufficient to reimburse the petitioner. If there's not enough money to reimburse the petitioner, then the court will not order the estate to pay for the fees and costs of the petitioner. Finally, as far in regards to fees and costs, the court may require the petitioner to reimburse the respondent's reasonable costs and fees if a court finds that the petition was brought in bad faith and not for the benefit of the respondent. So the petitioner can get their money back if it's brought in good faith and for the benefit of the respondent. If it wasn't brought in good faith, it was brought in bad faith and not for the benefit of the respondent, then the respondent can ask the court to have the petitioner pay for their fees and costs. So you want to make sure that you bring a solid and valid case, or you may end up paying the respondent's fees and costs. All right, that brings me to the end of this presentation. And just in summary, again, APS can bring 3 different types of cases: protective services cases, guardianship cases, and conservatorship cases. Does anybody have any questions?
So we've got a question here, Leslie, from Cecilia in chat. If we reported the sexual abuse to Medicaid and the caregiver reported it to the local police, are we still responsible to report it to APS?
Actually, I think there's an Emily question as far as mandated reporters. Emily,
Yeah.
can you answer that question, please?
Sure. I would say that you would still need to report it to APS if you're the one that witnessed the abuse, not just to Medicaid. Law enforcement would probably also report to us, but until you know that it's been reported to APS, you'd be responsible.
Thanks, Emily. And it looks like Richard and you have been asking questions and answering them in chat too. Is there anything you want to say while you have camera again about that, or is that fairly well wrapped up?
Oh, I do have another question for Emily, if I may.
Sure.
I don't want to interrupt with your scheduling with your other speakers, so let me hold off on asking that. I'll put it in the chat because we've got other speakers as well.
Okay, that sounds fair. Thank you for being courteous and conscientious. Is Michelle, do we want to roll into the next speaker now?
Yes, Buda, you're up next.
Good afternoon, and thank you for having us. As we were introduced earlier, Shanika Clark Nelson and I are here on behalf of the Commonwealth Attorney's Office. And what we end up doing is we really, in this whole process, end up being, I want to say, the tail end until the next chapter for the individual who is alleged to or proven to be abused. I'm going to share a PowerPoint presentation, if I may. So if I may have the power of the share.
You should be able to, Buda, if you click share screen. Yeah, there we go. Fantastic.
You are a lot faster than I thought you were. So good job. Thank you. All right, so let me just move my picture screen here. Okay. So what we wanted to do is come to this conversation by way of talking about what our office does, but more importantly, how we as a community can speak to the fact of how do we protect our elderly. In our office, we view the prosecution process almost like the medical profession, where when somebody's coming to our office, unfortunately, a lot of bad things had to happen. A lot of missed opportunities had to occur, and that person was not safe in this process. So what we want to do is actually always to collaborate with our law enforcement partners, adult protective services, community members, doctors, anyone that comes into contact with our elderly, to make sure that we are in the best way that we can in a position where we are able to stop the harm so that we get to the point that that person or that issue could be addressed early on. So let me do this. Some of these slides I'm going to go through rather quickly just because a lot of it has already been addressed by our prior speakers. So what we wanted to also be able to speak to is the fact that with elder abuse, it hits all of those different categories: physical, sexual, psychological abuse, neglect, and the financial exploitation. Now, I will also share this in my prior practice. I also was an adult guardian ad litem. And where we saw in that role, where I saw in that role a lot of times was the financial exploitation and neglect that family members accused the caretakers, who were other family members, of having committed. So it was a tough situation trying to work and navigate through the domestic relationships. But that was the obligations that we had, which is to do the investigation and to see what exactly was going on and where the next step of any sort of entity involvement should be. Do we involve adult protective services? Do we involve law enforcement? Elder abuse is also something that what we see is we see it in the public and the private sector with our caretakers, be it in a assisted living situation, is it in something where they are not able to take care of themselves almost on any level because they are incapacitated and that they are in an inpatient facility. And a lot of that sometimes comes by way of the neglect where they are housed and they're not properly taken care of. So those are things that we also see sometimes. And this a lot of times is also handled on the civil side, where somebody ends up taking a civil action against some of these businesses. But we're again going to focus on the criminal aspect of this. Some statistics, and as I think we pre-recording and pre-show, we had this conversation where what it is that we have a lot of our population right now is now falling into that category of aged 60 and older. So our numbers for elder abuse are going to be increasing just by way of fact that our population is increasing. According to statistics from the Department of Justice, elder abuse affects at least 10% of our older Americans each year. They also put that into this Center for Disease Control indicated that it's 1 in 10 people aged 60 or older who live at home experience abuse, including neglect and exploitation. So it's not just a matter that they're being taken care of by a unrelated third party, but even in their own homes, that is the situation. Between 2002 to 2016, more than 643,000 older Americans were treated in the emergency department for non-fatal assaults, and over 19,000 homicides occurred. We heard earlier that APS does not investigate fatalities, that goes to the medical examiner. They're the ones who initiate the investigation, make a determination if whether or not there's an expectation or belief that there was something unnatural that occurred or something that was criminal that may have occurred. In our office, we get those reports. And a lot of those reports that we get from the medical examiner are from falls. They also end up becoming trauma to the person's head, and that could also be from a fall, or it's an overdose or a mismanagement of the medications. In cases like that, it really is very hard to make a determination unless there's a witness to be able to say whether or not there is any wrongdoing or any criminal behavior. Excuse me. In our office, we don't have any investigatory abilities. We don't have investigators in our office, so we're very reliant on witnesses, the medical profession, as well as our law enforcement partners to be able to do the investigation and make a determination as to what occurred and is there an allegation that can be supported that there has been criminal action. Nursing homes, they were also talked in there where a situation with the adult population enters a nursing home. Here, what we have just done in 2010, and so I apologize for some of these statistics because they're not updated on a regular basis by the authorities who maintain these records to be able to say what is the 2020 stats. But back in 2010, there was about 3% of the seniors 65 and older were in nursing home residents. In Virginia, that number is, and it's a wide variance, between 2 and 2.9%. When you drive around in Loudoun County, you'll also see a lot of these 55 and older communities because they are trying to support, excuse me, housing needs of our aging population. The demographics we have is people 50 years and older account for 36% of the total population. Of that number, when we start bracketing them off, 65 and older is 17%, 75 and older is 7%, and 85 and older is 2% of the population. When we start thinking that, especially when we get to our age or my age, 75 is no longer old. 85 now might be old, but it's something that the life expectancy is increasing, so that we have to figure out a way that we can make sure that our elderly are safe in this where they find themselves in life. Abuse and neglect of incapacitated adults actually has a special code section. So let's make this very clear. These are not the only code sections that would apply to this type of behavior or any harm to the elderly. But when we're talking about a special area of law, they have carved this out so that it actually deals with an incapacitated adult. We have the definitions that we saw earlier as to what exactly does that mean for this code section to apply against a wrongdoer. That wrongdoer has to be the person who is responsible for the care of the incapacitated adult. And that basically means anyone who has the responsibility for that individual by operation of law or who has assumed that responsibility voluntarily, by contract, or in fact. So that could include family members, right? It could include the home daycare, home healthcare provider. It could include somebody who is in a nursing facility. When we talk about abuse, that is basically the knowing and willful conduct that causes physical injury or pain, or else, as we also heard earlier, the knowing and willful use of physical restraint, including confinement as punishment or for the convenience, or as a substitute for treatment. Neglect is the willful failure by a responsible person to provide treatment, care, goods, or services which result in an injury to the person or endangers the safety of an incapacitated adult. And then again, with incapacitated adult, as we saw, it's not the elderly only, but basically means anybody over the age of 18 who is impaired to the extent that that person lacks sufficient understanding or capacity to make or communicate or carry out reasonable decisions concerning their well-being. There are penalties that are associated with that abuse, obviously on the lowest level. If the injury does not result in a serious bodily injury or disease to the incapacitated adult, it could be a class 1 misdemeanor consequence that may result in that person being confined in jail for a period of not more than 12 months and a combination of a fine of not more than $2,500, either or both. If it is a more significant situation where that is a repeated offense, well, then that rises to a felony offense of a class 6, which includes the same punishment option as a class 1, or a period of not less than 1 year or no more than 5. Then if we go to a situation where the incapacitated adult, in that particular case, the abuse or neglect has resulted in a serious bodily injury or disease to that person, it becomes a class 4. Class 4 felony has a term of imprisonment of not less than 2, but no more than 10 years, and a fine of up to $100,000. And then the most serious one that is particular to this as far as the injuries relative to it is for a class 3 felony, and that is if it results in the death of the incapacitated adult. And that is a term of imprisonment of no less than 5, no more than 20 years, and a fine of not more than $100,000. So please also understand, depending on the act that resulted in the death of the incapacitated adult, because what we're talking about here is the abuse and neglect. That does not mean that if there is a greater act or harmful act towards that person, that it could not be a aggravated malicious wounding or a murder, which would have even more egregious consequences. So I don't want to make it sound like, you know, if someone kills a person who's incapacitated, that the maximum punishment for that person would be the class 3 felony. No, it's just as if it's based on an abuse and neglect situation. We discussed the different types of elder abuse, and basically there are 7 types that fall within the criminal statutes, which is the physical, sexual abuse. You have emotional, psychological abuse. Those would most of the time, the physical, emotional, psychological, if the person is able to verbalize what's going on, those can be substantiated by medical records. Abandonment, neglect, financial, material exploitation, and self-neglect. Now, self-neglect also becomes that if I'm incapacitated or I can't take care of myself, or somebody's responsible for my care, them allowing me to live in my inability of being able to provide for myself or care for myself safely, that may render that person subject to having been prosecuted under the basis of neglect. Individuals who might be the causers of the abuse or neglect can include family members, caregivers, fiduciaries, because again, we're talking about the financial crimes, friends, and neighbors. Risk factors that come into, that are related to elder abuse, a lot of times are somebody who is under some sort of disability, which could include the dementia, mental illness, physical impairments, or substance abuse. Sometimes, though, even if they don't have those limitations, the fact that they are isolated and subject to the undue influence of somebody else, or they're also they have lack of social support where that person's relationship is so important to the elderly person that they then fall subject to that person taking advantage of their situation, or when they live with other people. And as a guardian ad litem, I remember being appointed on a case where the adult daughter, her husband, 4 kids lived with her father, but that elderly parent was taking care of, based on how they manage the finances, all of the needs of the family, and the family would go on vacation on his income. The family would use his money to pay for all of the expenditures. And it was not brought to the attention of the courts until it was brought to the attention of APS, where we were able to determine that different things had to happen. Now, this obviously can go further, where it could become a greater harm, where they're taking away the financial ability for the elderly person to be able to sustain themselves. And it can be by, I'll use the word very purposefully and loosely, stealing from them, creating gifts to themselves, making expenditures for their own family members that person, while they were living, was not making such gifts, or exceeding the financial capacity of that person to sustain such gift giving, that it does become then the financial exploitation. I'm going to skip this because we already talked about adult protective services and the mandatory reporting. That was very well covered, so there's no need for me to repeat that. Consent and capacity and undue influence, these are elements that we would have to be able to establish to successfully prosecute a case. The hard time sometimes is that you don't have a direct witness who is seeing this, and the elderly person may not have the capacity to be able to speak to it. So you're left in trying to collect information that surrounds the incidents, such as financial records, any missed appointments with doctors or professionals, things in that sense, where you can see that this is something that just does not appear to be somebody who's appropriately taking care of the elderly person who is in their care. The decision-making capacity is another one where family members, a lot of times, or the person who is in the social circle of the elderly person, will make statements such as, well, they gave me permission. And when someone is interviewing the elderly person, at some point, the person may say, no, I didn't know. At another point, that same elderly person, when asked again, may say, yes, I did. So we just have the tough evidentiary issue to be able to establish what exactly was the consent or the capacity to render such consent for that person. Attorneys many times have to consider the following things, as we just were talking about, is what can we learn to do? And sometimes from a prosecutorial perspective, we can't successfully prosecute the case because we don't have the information that we need to be able to do that. But what we then end up having to do is try to use the resources we have as a community. And that could be involving adult protective services. That could be involving other family members to be put in a situation where they can go forward with the courts to get protective documents that allow them and give them the power, such as the power to make the medical decisions or the financial decisions of the person, so that the interested and appropriate person is in that life of the elderly person, so that we are able to, if we can't protect them from the criminal justice system, we can at least protect them from other avenues throughout our community. What we want to close with is that it is with working with the elderly and any involvement that there is, it is the community's opportunity and duty to protect our most vulnerable population. And how that happens is literally by, when we see something, is to say something. Those protective measures are ensured by doing the following: contact with our elderly. If it is a family member or a friend or a neighbor, somebody see, to have regular telephone calls. Now that we've all learned how to Zoom everything in life, having virtual video meetings, meeting them in person. If it's appropriate, to review their financial and medical records. Staying in contact with family members of the elderly is the best way for us to monitor what is going on as to whether or not they are safe. Also asking them questions. Sometimes the response may come back as being odd, but do not disregard it. Do not just dismiss it offhand without asking more additional questions. And also, there's a lot of times we have our own radar that says something just isn't right. If that is the case, let someone know what you think may be happening. There's no harm if you're wrong. If it's investigated, somebody says, you know what, nothing untoward is going on. It's like, okay, well, thank you for checking. right? We don't lose anything that, whereas sometimes if we don't follow through what our instincts is telling us, then harm does occur and we can't undo it. And then that's when the vulnerability of the elderly actually comes to the forefront. And what ends up happening is that the worst things happen is that they weren't able to protect themselves, and we as a community didn't help to protect them. As I indicated, we are dependent as a prosecutorial office on outside investigations and complaints. Our approach with our office is to have a holistic community approach to our prosecutions. When we do have a case that is going to go forward and be prosecuted, what we want to be able to do is to have a harm-based approach. What was the harm to that vulnerable victim? What occurred? Then what we want to be able to do is to collaborate with other agencies to establish safety for that elder victim. We ourselves in our office don't have that capacity or the resources to do that, but within the community, we can be able to make referrals and use the strength of the other entities and agencies within our community to be able to assist. We also, within these prosecutions, always want to consider the wants and needs of the elder victim to the ability that they are able to so communicate. And if they can't do it, then what we want to do is engage their family members and other community members so that we're able to provide the long-term solutions. So at the end of the day, what we want our message to be for our community is to be able to say this. Please stay in contact with our elderly. They are very much our very vulnerable population, and that we want to be able to do is to make sure that we're protecting them as they continue aging and maybe losing some of their ability to self-protect. And that is the end of our presentation.
Thank you so much. So informative. I want to thank everybody again for joining us today, and remind everybody that a recording of this presentation will be available on the Loudoun Senior Interest Network Facebook page. And so, you can always send a link over there. You can, you don't have to like that Facebook page to be able to view it, but you can follow more of the things that we're doing at Elson on our Facebook page.